9 of supplemental list today's item, my lord. Kindly adjourn the matter, my lord, today because Mr. H.R. Chaudhary, senior advocate, engaged in this court. He's not some time for going through the record, my lord. Kindly fix the matter.
Okay, item 9, no? Item 9, you right? 9, no. Yes, you file your WO, you have not filed.
On the first application, I'm not aware of it, but let me find Anna.
This item 9 is the application under 430. You have not filed your.
Oh, but I found a record here. I number kitan?
I number 1232. Yeah, it will be-
But I got
Fine. So we'll give you 4 weeks time. Miss B. Buyan, APP, is granted 4 weeks time to file written objection to the application under section 430 BNS. Then in the main appeal, you write. The court reveals that paper book has not been prepared. List the matter after 4 weeks. Give a date. After 4 weeks. 13th of the-
Excuse me.
May I apologize? I beg to mention item number 2, Lordship.
Yes.
I have circulated the.
Okay. Adjournment prayer has been made on behalf of Mr. H.R. Chaudhary. No, made by Mr. H.R. Chaudhary. Counsel for the appellant.
No,
So,
Lordship.
it is not-
Adjournment on behalf of the PP Meturam.
Oh,
Yes, he has some difficulty.
okay. Adjournment prayer has been made on behalf of the PP Mizoram
Yes.
by Mr.
A. Burua.
A. Barwa, Learned Counsel.
Yes.
Kusam. List the matter. Give sometime in March.
Obliged.
May I please also beg to mention listing for IL Lordship for orders
When?
on 19th of Jan, if possible, Lordship.
19th of Jan. ठीक है.
Hi, President. Milord, criminal appeal, Milord. Pending. So, let's
When?
start on 9, Milord.
On 9.
9.
Criminal appeal.
Nine.
No, we're having a function 11, so it's going to be, we're going to be very busy.
Then
After Bihu.
April 19.
After Bihu.
Lordship, in regards to item 6, Mr. Datta is appearing in this matter, but today for some personal difficulties, he won't be able to apprise the court. I'm paying for an adjournment in this matter on his behalf.
On the prayer for adjournment made by Mr. S. Datta, Learned Counsel for the appellant. List the matter after vacation.
Obliged, Lordship.
After Bihu, vacation, say after this.
Lordship, in item number 1, we have filed our objection just yesterday. It's on not on record, my lord. Can it be taken up on some other day?
Have we taken up now also? What is there? We
Let's
will
come up with a system.
or hasn't come. How does it matter?
Lordship, because the observation made by your lordships that they have a case in their favor.
Have a case. Okay, so yes. What?
This matter may passes over for timings. Lordship, my senior is on late.
No, objection or copy to record or ahana. So can we need copy serve kora hoise.
Okay, Lordship.
Okay, what?
Belek na halo homo. He has no objection, he said.
For what? For listing the matter when?
Some other day.
Some other day. When?
Any day, come lordship.
Day after?
Copy served on them.
Day after?
Maybe.
Okay, right. On the prayer made by Ms. Bui Buyan, who submits that written objection has been filed yesterday. List the matter on Thursday.
Publish.
Supplementary orders, item 11.
Let plea, your Lordship. We have filed this petition under 430 for suspension of sentence. Appeal has already been admitted, Lordship.
But time to file written objection.
Definitely, Lordship. A notice to be issued to the it is a POXO case, Lordship. Appeal against POXO. So a notice, order notice may also be kindly be.
But in the main appeal, you did not take any steps for
Miscommunication is, I will take by tomorrow, Lordship.
okay, right. 11. Mr. S.K. Podar appears for the applicant. am praised for suspension of the sentence under section 430 BNSS. Issue notice. Returnable in 4 weeks. Ms. B. Buyan, APP is granted 4 weeks time to file written objection. The applicant shall serve a soft copy of the application to the office of the PP, who shall furnish the same to the OC of the Missa Murray Police Station. In as much as the case is registered with the Missa Murray Police Station. No, in as much as
Mikiripeta PS, Lord.
in as much as the case has been registered with the Mikir Beta, my KIRBHETA, PS case number 119 of 2024. Correct?
Mikiripeta, Lordship. No,
Mikir Beta.
Mikiripeta and Morigaon district, Lordship. Within the district of Morigaon.
Not Missa Murray, huh? It's Mikir Beta. Okay. Mikir Beta, PS case number. Yes. The OC shall thereafter give a report on the notes served upon this point number 2. List the matter on give a date. Then in the main criminal appeal, right? As TCR has arrived, registry to prepare the paper book. Further, office note indicates that no steps have been taken by the appellant for service of notice upon the respondent number 2, as per the last order. The appellant shall accordingly take steps for service of notice upon the respondent number 2 in terms of the last order.
Oblige.
The matter on same date.
Oblige, Lordship.
Lordship, item 3 can it be taken after some time?
They are having a problem. Why?
After some time, today only.
Okay, I think no problem. After some time. Next. Yes.
May I please, your lordship?
So out here, the son killed the mother.
My lord,
Son killed the mother.
my lord.
That is an eyewitness.
My lord.
PW5.
Father.
Father is the eyewitness.
Yes. So what is to be done?
My lord, squarely covered under the judgment delivered by my lord in a recent case, Nipam Phukan. To my humble understanding, my lord, subject to correction, this is a case where the section 300 exception has to be applied. And I will try to
Exception 3,
yes, my lord, exception 4,
4.
my lord.
There was a fight
Yes, my lord. And there are
between the brother-in-law.
not only the brother-in-law, what has happened in that fateful day, the accused first went to consume alcohol, taking money from her mother, from his mother, and he returned after being intoxicated. And again, he further demanded further money, which her mother only paid him 30 rupees.
His mother gave.
His mother paid him 30 rupees, to which he was infuriated and he started abusing his mother.
Correct.
Thereafter, what had happened is a maternal uncle took objection and raised objection and also took a bamboo stick to assault him. In return,
Was there any assault?
yes, my lord. Yes, my lord.
Evidence is there.
Yes, my lord. Evidence is there. This is the testimony of PW7.
Who
The
is he?
maternal uncle. He said, yes, there was a altercation and there was an assault. I assaulted him first with bamboo stick and he assaulted me in return with the same bamboo stick. And in between, his mother interfered and also slapped the accused,
Ah.
who was already under intoxication.
And it was in that moment where the vegetables were also seen chopped in the kitchen. That was the testimony of PW6 when she went in the place of occurrence. So, and that is a household utensil, knife, a boti dao. And immediately under that circumstances, with a single blow,
To which part of the body?
neck, my lord, neck.
Neck,
Yes,
Neck.
my lord.
vital part.
My lord. My lord has dealt with such a situation in Nippon
No,
Fukan, my
the-
lord. I will place that judgment, my lord. Very recent judgment, my lord, authored by my lord,
The problem is out here,
my lord.
the blow with the weapon, with the knife,
My lord.
or dao.
Boti lottery,
Yes,
that vegetable cutting used in kitchen,
Okay,
that.
sir. It is not,
With the
not
boti.
something which was brought. It was there
but
in the household, yes.
whatever,
Household item, my lord.
then you aim it at your mother
Hmm.
and at the neck.
And the neck.
But he was under severe influence
But
of
he
alcohol,
fled.
my lord.
Different.
He fled.
No, he did not fled, my lord. There are evidence to that effect. He did not fled.
Okay, whether
Yes.
he fled or not,
Yes, that is secondary issue, my lord.
The
That is
different-
different issue, my
the
lord.
issue is that he killed her mother. That is
Mother,
the
yes,
that's
yes.
a disputed fact.
My lord.
The only issue is whether he is trying to bring out a case under section 304, part
Part 2, my lord.
part 2.
Yes, my lord.
Whether it will come under part 2,
Yes, my lord.
intention.
Yes, my lord, because he was under intoxication, my lord.
Part 2 is without intention.
That part,
1 is with intention.
correct, my lord. Correct, my lord.
Now, intention can be constituted how?
My lord, with a premeditated mind, my lord.
But won't it also depend upon the weapon and the part of the body?
Yes, my lord. But he was under intoxication, my lord.
Intoxication, was it something
And-
given to him under protest by him? Or did he consume it willingly?
He consumed it willingly, my lord.
Can you take the plea of intoxication?
That is what my lord has already held in one of the judgments, my lord, very recent, Nippon Fukan, my lord. I'm relying upon that judgment, my lord, heavily. Only 2 paragraphs, my lord. My lord, if my lord may permit.
Yeah, section 3 can be, section 4 can be. Let us see the evidence of PW 5 and 7.
My lord, my lord. My lord, may kindly take the paper book once.
Yes,
Page number 15, my lord.
yes.
May I place it, my lord? He is the informant and the father of the accused, of the convict appellant, my lord. Deceased Geeta Nandi was my wife. Accused Shankar Nandi is my son. The occurrence took place on 13/3/2016 at about 10:30, 10:45 a.m. I was in the house. My son is a habitual drunkard. He also used to consume drugs and also had all bad habits. On the date of occurrence, I was in the house. my son Shankar demanded money from his mother. My wife gave him rupees 30, to which he was not satisfied and started to abuse her in filthy languages. My brother-in-law was also there. He raised objection in abusing his sister. As a result of that, a quarrel was picked up in between my son and my brother-in-law. My son tried to assault my brother-in-law. Then my wife objected and tried to resist my son. At this point, my brother-in-law left the place. But my son Shankar picked up Boti Dao, a sharp cutting object, and gave a blow aiming the neck of my wife. I was the only person present there and I tried to resist him, but I could not. The neck of my wife was almost severed and she immediately fell down and died. Then I informed my neighbor, namely Decca, I forgot his name. I requested him to call the ambulance. He came to my house and saw the incident, and thereafter, without asking me anything, he left for the police station. Immediately after the occurrence, my son fled away with the Boti Dao in his hand. I do not know where he had gone, but I heard subsequently he deposited the Boti Dao at the police station. Police came there and investigated the case. Dead body was forwarded to GMCH for PM examination. OC also came to my house and asked me to give the FIR in writing. Accordingly, I lodged the FIR with police. Exhibit 6 is the FIR and so and so, my lord. These are the markings. The cross. Police examined me. Shapon Kumar Biswas is my brother-in-law. He used to stay in my residence whenever he used to come to Guwahati. It is not a fact that my brother-in-law used to have quarrel with my son regularly. It is not a fact that due to quarrel with my brother-in-law, accused Shankar Nandi used to stay separately. On that morning, my son once took money from my wife and consumed liquor. Well, this is very important. Again, he came back to demand money from my wife, and then brother-in-law was there. As my son started to abuse my wife, my brother-in-law objected. It is not a fact that a quarrel was picked up in between them. My son tried to assault him, and then my wife tried to resist. It is not a fact that during quarrel, my son came with a Boti Dao in assault. My brother-in-law and my wife fell in between and received the injury. Well, rest of the depositions are in the nature of suggestion and denial. And my lord, next is PW7 at page 19, my lord.
Look, there is nothing here that there was any assault from the uncle to
But
the.
that is there in PW7, my lord.
Let us see.
Yes, my lord.
Please.
Page 19, my lord. Informant Subhendra Narayan Nandi is my brother-in-law. Deceased Geeta Rani Nandi was my sister. Accused Shankar Nandi is my nephew. The occurrence took place on 16/3/2016 at about 10:45 a.m. On that day, I was at the residence of my deceased sister. It was a Sunday. I was working at the garden. Shankar was in the house. In the morning, he took money from my sister and went out. He came back again after consuming liquor, and thereafter again demanded money from my sister. On this issue, a quarrel was picked up and Shankar was uttering abusive and obscene words towards my sister. Hearing the same, I went there and scolded Shankar and also told him not to use or utter obscene words towards his mother. At this, Shankar became enraged and pushed me to a nearby bed and thereafter pressed my neck. My sister rushed there and slapped him twice. But this is the victim who slapped the appellant twice. Thereafter, Shankar went inside. My sister and my brother-in-law also went behind him. I came out from the house. After 5-7 minutes, Shankar came out with a Boti Dao in his hand. I was working with the Dao in a garden and he also took my Dao from me and left the place. After he left, I entered the house and saw my sister was lying dead with cut injury in her neck. she was in a pool of blood. My brother-in-law was instructing me to take her to the hospital, but as she was no more, I went to the Goshala police outpost. On going to the police outpost, I reported the incident. Police accompanied towards the house of my brother-in-law. On way, I saw Shankar was standing there in a connecting road with the boti dao and the dao in his hands. I indicated the police towards him, and then police apprehended Shankar and took him to the police station. I was dropped there. I came back to the house. Police again came back there. Some other police officers also came. One madam also came there, and she wrote some papers and obtained signatures of my brother-in-law. Thereafter, the dead body was forwarded to GMCH. Police recorded my statement. Now, my lord, the cross-examination. I work at so-and-so, so-and-so. My lord, leaving 4 lines. The 5th line in the middle, I used to stay there 1-2 months at time on the date of occurrence. Shankar Nandi assaulted me with a bamboo stick. I also assaulted Shankar with a bamboo stick. My original house is at Lamding. I used to stay in the house of my brother-in-law for the purpose of study, and my sister Geeta Rani Nandi made all expenses of my study. After 6-7 months of marriage, Shankar started residing separately with his family. My brother-in-law was a cancer patient, and he had operation at Cancer Hospital, Guwahati thrice. He had also an operation of hernia. All of these occasions, I was with my brother-in-law. He had good relation with me. At the time of occurrence, I was there. My brother-in-law and my sister were also there, and Shankar was there. As Shankar was uttering obscene words to my sister, I gave him blow with bamboo stick. He also assaulted me with the same bamboo stick. It is not a fact that I was not working in the garden. It is not a fact that assaulted by Shankar Nandi, I rushed to him with a dao. Well, the rest of the deposition is in the nature of suggestion, which was denied.
To page 29.
My lord. Yes, my lord. Question number 15. He has admitted, my lord.
He has
See-
admitted what?
My lord,
He has not admitted.
when the occurrence took place, my lord, my father was not there. My maternal uncle was also armed with dao. My mother suddenly entered in between us, and she received the injury on being caused. My lord, that part is missing in my
It
record.
was by my
By-
maternal uncle.
Yes, my lord.
I was innocent. I told police about the real incident, but no one believed.
Yes, my lord.
So his
But he has taken his plea in the
his case
313.
is that he did not cause the death of his mother.
Yes,
His,
ma'am.
his uncle caused the death of his brother, of the mother,
My lord.
due to the mother suddenly coming in between.
My lord.
Now, did you stand as a witness?
No, my lord. Well, this is I'm not praying for acquittal, my lord. Well, to be honest, my lord, this is
So what do you
Yes,
mean?
ma'am.
Do you mean to say that your answer?
it was
explanation-
completely unintentional, my lord.
Just understand.
My lord.
Let us finish
My lord.
the question. So do you mean to say that the explanation given by you to question number 15 is false?
Well, so far as the evidence is there at the appeal stage, my lord, I will have to concede, my lord.
So you say you're giving a false statement
My lord,
under
so far,
313.
my lord, under 313, what
So
he has
if
given,
you
my
give
lord,
if you give a false statement, a false explanation
my lord.
under 313, what is the consequence?
No, that is a separate
No.
consequence
We have
to
to, we
follow,
have
my
to
lord.
consider.
My lord,
You see, when you have been given a chance to explain
my lord.
the evidence adduced against you, which is detrimental to your case and you give a false case, a false explanation, what is the consequence of that? What can be inferred from that? What is the
So
Supreme Court
adverse
say?
inference, my lord.
Adverse inference. It provides a link.
My lord.
What about question number 11 and 12?
Yes, my lord.
So this 11
he-
and 12
he may-
explanation given by you is false also?
My lord, so far as the deposition is concerned, if it corroborates with 313, I don't have any explanation to offer, my lord. But so far as
No, no,
313
you
is
gave an
concerned, it was the
explanation.
stand of the accused, my lord, at that point of
Your case is when we look at question 11, 12 and
my
15,
lord,
you are trying to deflect the blame
my lord,
on your uncle.
my lord,
Correct? You are saying that he is the cause of the death.
my lord.
So now you are going towards Shillong
My lord.
or you are going towards West Bengal. Now, which route are you flying? You are flying in a plane.
My lord,
Your plane cannot go in two different directions at one go. Cannot break into two and half will land there, half will land there. It has to go one way. So which is the correct? So your explanation and the 313 should not be believed.
but even if the
No, it's not,
story,
even if is it possible
my lord.
for
Yes, my
one
lord.
plane,
Yes, my lord.
one to land in Kerala and one to land at Delhi at the same time?
My lord, there are always contradictions between the defense and the prosecution in
we are
the
asking-
story
that is why we
that
are
is built
asking.
up, my lord.
That is why we are asking you.
My lord,
Please explain your conduct
my lord.
or an explanation.
My lord, this
it
is what,
a correct explanation given by you or not a correct explanation?
as per my instruction, my lord, I have specifically put a question so far as question number 15 is concerned. And the stand of the appellant was that this is correct.
What is correct?
This is what has happened. And he still said that this is what has happened. But because there are no corroborative evidence to substantiate this stand, so my lord, and even taking the best case of the prosecution to be true and correct, I am only on the proportionality of the punishment that was awarded.
Okay, you are only on the proposal. So you are not on the merits of the case.
Yes, man. Because I don't have any other means, my lord, to correct the.
No, you see, there is one thing.
Yes, man.
You could also have given evidence as a
Yes, my lord.
witness.
My lord, because this was conducted by the he did not have an means to engage his own advocate, so this was done by after lot deliberation, my lord. And at that point of time, we know, my lord, in trial courts what happens.
You cannot blame a lawyer just like
No, I'm not
Yes.
blaming lawyers, my lord. He was not in that state of mind, or he was not aware that he could even lead defense evidence. And because I don't have means to improve the records now, my lord, I am falling back to the best case of the
In your
prosecution,
161 statement before the police,
my lord.
what did you say? Did you lay the blame for
My
the
The
for the
161,
action
my lord,
for the death of your mother on the uncle or not?
my lord, the 161 is not with me.
Let us see your 161 statement. Yes, show it to her. Show it to the AP. Okay, what is the judgment that you said is
Yes, my lord. Madam? My lord, in fact, this judgment is helping us in trial courts in many matters, my lord. Now,
Hopefully it's helping to do justice, not otherwise.
yes, my lord. Yes, my lord. My lord, may kindly briefly refer to para 46, my lord. Para 46, second last page.
Yes,
As has been held by the Supreme Court, the test to be applied to see as to whether the sudden provocation on the part of the deceased to the appellant was grave or not is whether a reasonable man would likely to lose self-control as a result of such sudden provocation. In the present case, the admonition and the reprimand given by the deceased to the appellants who were under the influence of alcohol not to create nuisance on the road and to go home was sudden and unexpected. The appellants were not expecting such a sudden and unexpected admonition reprimand. Besides, the appellant being apparently under the influence of liquor, they could not have said to be reasonable person in the ordinary sense of the term. As there is a vast difference between intoxicated person and a person who is not under the influence of liquor. Though a reasonable person may not lose self-control as a result of such provocation, it would not be unexpected for a person under influence of liquor in regard and react to the said provocation as a grave provocation. The evidence of PW1 is to the effect that soon after she heard her husband asking the appellants to go home instead of making a nuisance, she heard her husband calling her by saying, "I am dying, do me." Further, the evidence of PW3 is to the effect that he heard the deceased and appellants quarreling between them. The deceased was soon thereafter found stabbed and he died after about a half hour later. On considering all the above, we are of the view that the appellants being under the influence of liquor at the time when they were admonished by the deceased, it can be said that they were subject to a grave and sudden provocation, and as a quarrel had apparently ensued between the appellants and the deceased, the same apparently deprived the appellants of the power of self-control. In view of the appellants being under the influence of liquor, the assault of the deceased by the appellant at the spur of moment, while apparently being deprived of the power of self-control, leads us to believe that the present case comes within the exception 1 of section 300 IPC. As a result, we are of the view that the case of the appellants would come under section 304 part 1 IPC, as the use of a dangerous weapon on a vital part of the body leads us to believe that there was a sudden intention to cause death. Accordingly, we convict the appellants under section 304 part 1, as we find that the appellants had caused culpable homicide not amounting to murder for causing death with the intention to cause death or such bodily injury as was likely to cause death. Further, there was a common intention to cause death or such bodily injury as was likely to cause death. The appellants are now convicted under 34 IPC. Consequently, the impugned judgment dated so-and-so passed in case sessions case so-and-so insofar as conviction has been made under section 302 34 IPC, the sentence passed on the basis of judgment is satisfied.
actually, there is a mistake here in the word.
My lord.
It should be as the quarrel had suddenly ensued, not apparently.
My lord.
In the para 47, the fourth line. Instead of apparently in the fourth line, it should have been suddenly. But out here, you see, in this case, they were unknown person.
Yes, my lord.
Out there is between the mother and son.
My lord.
The provocation was started by him. The provocation was not started by the uncle
My lord.
or the mother.
My lord, the
Oh. The he demanded money after being drunk. She gave him money. He was not satisfied. He started cursing at his mother,
my lord,
which naturally infuriated the uncle.
uncle, my lord.
Naturally, he will look after the sister.
My lord.
Now, in this case that we are dealing with, out here the issue was these two were outsiders who had come slightly, intoxicated. And this stranger who lived in the house, he comes and scolds them.
My lord.
So the provocation in this case that you're referring to had come from those persons who had, yes, unexpectedly, and who had killed. But the provocation was by the person inside the house. But in your case, the provocation is by the culprit himself. The provocation out here is different.
Provocation, so far as the accused is concerned, my lord,
Ah.
the
You see, it says that culpable homicide is not murder. If the offender was deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation. Where is the provocation by the mother? The only provocation by the mother is that she slapped him. Whether that provocation of slap and the resultant severing of her neck can be said to be proportionate. That is another issue. Yeah. And she slapped him because you were strangulating the uncle and also hitting him back.
But so far as the provocation is concerned, if we go by the testimony and the cross examination of PW7, it was PW7 who assaulted the appellant first with bamboo stick, and in return,
Maybe.
yes, my lord. So, my lord,
Maybe either
that's-
one.
because this is a part of the same transaction, my lord,
Maybe.
in the same incident, my lord.
But what does exception one say?
My lord.
Exception one says causes the death of the person who gave the provocation
Yes, my lord.
or causes the death of any other person by mistake or accident. Where is your stand that you have caused the death of your mother by mistake or by accident?
But may kindly see explanation, exception 4 once, my lord.
Section 4.
Yes, my lord.
Yes.
Culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel and unusual manner.
So the first thing is there has to be a quarrel.
Yes, my lord.
Secondly,
My lord, it does not say who will initiate the quarrel.
it does not say,
Yes, my lord.
but then it says upon a sudden quarrel and in a sudden fight. There has to be a sudden fight.
Yes, my lord.
Where is the fight between you and your mother?
But the mother slapped the appellant, and there was a sudden fight between the uncle and the appellant also. So there was at that situation, my lord, when 3 of the persons are involved in a fight and the sequence is not recorded. So far as the testimony of PW7 goes, my lord, it was the PW7 who initiated the fight, my lord. It was not the appellant who initiated the fight.
Maybe, but
So
then the-
therefore, my lord, I am covered under explanation 4.
Oh.
I am covered under
There was
explanation
no
4,
fight-
my lord.
There was no fight between you and your mother.
My lord, my mother slapped me.
So
And-
did you call that a fight between you and your mother?
My lord, so far as explanation 4 is concerned, my lord, we can,
Issue 4 is between the 2 persons who fight,
yes,
or the 3 persons who fight, or a 4 person who fight. Out here, your mother only came and slapped you because you attacked your uncle.
my lord,
He may have attacked you first,
my lord,
but because you retaliated or whatever.
Correct, ma'am.
As per your stand.
my lord.
Now, then the evidence of this PW7
Yes, my lord.
is that he went out.
He went out.
He went out.
Yes, my lord.
And then
But so far as PW5 is concerned,
uh,
PW5 says it had happened immediately. After he went out.
correct. No, who went out? After
Uncle. After the uncle went out, my
out.
lord. Yes. After the uncle went out and the appellant went inside. And the appellant was followed by the mother and the father inside the house. This is one part of the story, my lord. I tried to
No,
visit the place of
the
occurrence, my lord.
evidence of your father is after your uncle left,
Yes, my lord. At the
you
same
picked
time,
the weapon and killed your mother.
after my uncle left, I went inside.
Killed
And-
your mother.
And no, my lord. My mother and my father followed me inside.
And was there
And
any
thereafter,
fight?
what has happened, that story has not been revealed. But so
That-
far as
that is
testimony of
known only to
PW5
you.
is concerned, my lord.
That is known only to you under section 106 of the Evidence Act.
My lord.
What happens between the privacy of the four walls has to be explained by the person who was there. You have not given any explanation.
No, my lord, the eyewitness is there.
So
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 if we go by the
Say,
testimony of
that's what I'm
PW5 also,
that is what I'm saying.
yes, it happened instantaneously, my lord. So far as testimony of 5 is concerned, PW5.
But then the person who provoked you has left.
He have
Well, the
already left, and the
provocation-
main thing is that lordship, the father. Who will save his brother-in-law and put his son behind the bar? Of own father, lordship.
Provocation is my lord.
And so lordship, he used to do. His wife also left. Wife used to stay in other house. She also have said in PW6. He used to put quarrel. Wife of the accused, PW6. He is not that intoxicated that he
That judgment that you referred to.
My lord.
There are differences. Those were where
Well, the word sudden has been defined in the judgment of Vijay, which was referred by my lord in that judgment.
sudden.
Yes, my lord, and I'm squarely covered under this point.
But out here, you see, this is a different, the
facts.
facts are slightly different. In those cases, they were unknown to each other. But here it is your own
Mother. Own mother.
or an uncle.
My lord, we cannot impose our personal standards, my lord. This is what the judgment says.
No.
Because
no,
for
but then you see-
circumstances
No,
to
you
judge
see-
that person, my lord.
You see, it's very simple.
Yes, my lord.
A father scolding a son
My
or
lord.
a mother scolding a son will be accepted at a different level by the son than a stranger scolding that same person. Supposing my father scolds me or my mother scolds me, I will absorb that scolding in a different manner than supposing you scold me. Or supposing I scold you. You take it differently. And if that same subjects, the same scolding is done on the same subject by your mother or your grandmother or your son or daughter, you take it differently than what than the manner as how I scolded. That if I had scolded. So these are the reception that is, the manner in which you accept a scolding is different.
My lord.
And
No, this is
no
exactly what,
intention is not there, but he knows, Lordship. By
This is a-
picking a da or butti, Lordship, and that also stabbing in a vital part.
No, vital, the intention is there.
Intention is there.
Intention is there.
Intention is there.
Only thing is that whether it was Yes, Mr. Counsel, one thing,
my lord,
now, supposing we say
my lord.
that the mother's slap also amounted to a provocation.
My lord.
That is what you're trying to say.
Yes, my lord.
Now, whether the retaliation on that provocation has to be proportionate or it can be extraordinarily disproportionate. Supposing a provocation is, say, forget a slap. Supposing it was a scolding.
My lord.
Can I take a double barrel gun and blow her head off?
My lord, this is,
Or does the provocation and the retaliation be proportionate to each other?
my lord, to bring home the theory of proportionality, we must also not, I will suggest, my lord, that the circumstances and the state of mind in which the accused was there at that point of time in intoxicated state has also to be considered. Because even when I also was under utter shock when I took an interview, I was in conference with this like a appellant in jail, and he said that what had happened at that point of time, even he is very upset with that, and he has never applied for bail also. Right from the date of arrest till now, it has been almost 10 years, my lord. And even he says that at that point of time, what had happened, even I cannot make out. Because PW6 says he loved his mother very much. And he also helped his mother in household activities.
Naturally, he has to be good boy, and otherwise he will not get his pocket money or his daily needs.
My lord,
Instead of
So-
going to work and making money for himself
my lord.
in the real world, it's better to cozy up to his mother, wash dishes once or twice in a week, and get some pocket money. It's easier work.
So, my lord, under the influence of alcohol, we cannot equate him with a reasonable man, my lord.
That is there.
But 300 is applied, Lordship, in it.
Huh?
300.
We cannot.
Murder, Lordship, because all the four exceptions are connected with it, Lordship. It is a murder.
No, 300 has to be read not only with the exceptions, but it has to be read
With the
with the ingredients therein.
Yes, yes, my lord.
432.
Well, for a moment, can I place paragraph 20 to one paragraph? Vijay.
Yes. Yes. Rega-
22.2, my lord.
Regarding
Page
whether
677.
whether he's a reasonable person or not.
Yes, my lord, and the standard of the standard to be applied, my lord.
22.2.
My lord.
Yes.
May I place it, my lord?
Yes.
The main difficulty lies in deciding whether a certain provocation was grave or not. A bare statement by the accused that he regarded the provocation as grave will not be accepted by the court. The court has to apply an objective test for deciding whether the provocation was grave or not. A good test for deciding whether a certain provocation was grave or not is this: is a reasonable man likely to lose self-control as a result of such provocation? If the answer is in the affirmative, the provocation will be classed as grave. If the answer is the negative, the provocation is not grave. In this context, the expression reasonable man means a normal or an average person. A reasonable man is not the ideal man or the perfect being. A normal man sometimes loses temper. There is therefore, no inconsistency in saying that a reasonable man may lose self-control as a result of grave provocation. A reasonable man or normal or average man is a legal fiction. The reasonable man will vary from society to society. My lord, kindly note, a judge should not impose his personal standards in this matter. By training, a judge is a patient man. But the reasonable man or the normal man need not have the same standard or behavior as the judge himself. The reasonable man under consideration is a member of the society in which the accused was living. So education and social conditions of the accused are relevant factors. An ordinary exchange of abuse is a matter of common occurrence. A reasonable man does not lose self-control merely on account of an ordinary exchange of abuses. So courts do not treat an ordinary exchange of abuse as a basis for grave provocation. On the other hand, in most societies, adultery is looked upon as a very serious matter. So courts are prepared to treat adultery as the basis for grave provocation. But so far as the standards and the test to be applied, my lord, is concerned, these the social background, the intoxicated state, whether we can say that he was a reasonable man at that point of time, these all factors has to be taken into consideration so far as the proportionality of punishment is concerned, my lord.
No, that's not right. Only problem is mother.
Yes, my lord, that was the most difficult part for me also to accept this brief. my lord.
That is what we're whether the slap by the mother because you attacked, because you and your uncle attacked each other can be said to be provocation enough.
These all
Or
tests will
That
apply
is
for a reasonable man, my lord.
Huh?
These all tests are squarely applicable for a
But
reasonable
then-
man, my lord.
No, provocation. Say, a provocation by a child of 7 years.
My lord.
Supposing a child of 7 years slaps you. And a mother slapped you. And a total stranger slapped. Or slaps an intoxicated man. Do you mean that the reaction of that intoxicated man on all the three situations will be the same?
It depends on the what section of society he has come from.
No, no.
Because
focus
I
section.
have my
That-
personal experience, my
Worst
lord.
section of
Yes,
society.
my lord.
What I do not know what you call a good section or bad section, or supposing
My-
from the most illiterate person and from the most poorest person of society. Mother is a mother,
Yes, yes,
then and the child is a child,
my lord.
and the total stranger is a total stranger.
Well.
So will the slap by all three of them upon an intoxicated person be reciprocated in the same manner, according to you?
In
This is your-
the state of
this is the-
intoxication, my lord,
this
there
is the
cannot be any
issue that should be
measurement,
decided by us.
my lord. My lord. Yes, my lord. Yes, please. My lord.
What is the, here, it appeared that himself was quiet. He was accusing.
My lord.
Left them. He was wrong in that. No reasonable man of that. Suffer thou when given the neck.
When he, the
This
accused,
also, they were your uncle, your mother, and who
All
are
family
looking
members,
after-
my lord.
who are looking after,
then his mother.
well-being.
My lord.
And it's not that they they started the quarrel.
quarrel. And when he pressed his uncle, then only his mother came to him and slept.
Well, that is why, my lord, that is why, my lord, in para 22, it says the reasonable man means a normal or an average person.
Correct. But then you see, this is not this para 22 does not cover all types of situations.
Yes, yes.
They're different situations.
I completely agree.
So the facts of a case can change the presidential value of a decision.
My respectful submission would be, my lord, if he was would not have been in an intoxicated state, he would not have done this.
But he is a regular
Probably.
habitual.
Without
always.
the influence of alcohol,
Okay,
he
supposing
would not have done this.
let us say, supposing a 5-year-old had slapped you say you and your uncle were fighting.
Yes, ma'am.
Your nephew, who is 5 years old, or your niece, who is 5 years old, to protect your uncle, comes and slaps you.
My lord.
Would you do the same thing that you did to your mother?
No, can't say without the influence of alcohol.
No.
Because under influence of alcohol, my lord, people do all sort of things, my
Why
lord.
not? But it depends. It depends. You see, under the influence of alcohol,
My lord.
when you go home till late at night after a party, and you know that you're supposed to be back home by 10, but you go home at around 4:30 in the morning, and your father is waiting by the door, going to give 2 bits of his mind to you.
But in influence of alcohol,
Then
so he have remembered.
with the alcohol, probably you will recognize that is your father.
Yes, yes, ma'am.
And you'll be expecting something. Oh, I've done something wrong. But if some stranger meets you on the road and tells me, hey, what are you doing 4:30 in the morning? Where are you going? What are you going to say? Your reaction will be what? Yes, stranger. What business is it to ask me where I'm going at 4:30? I'll go wherever. Who are you? Get out of my way or something you do. So, I mean, the thing was, unless you are in such a situation that you are so intoxicated that you do not know anything that is going.
That-
But the thing is that in your case, you went, had your quota, not satisfied, you came again for money, asked for money. So you were in your senses. It was not that you were totally
Out of sense.
out of your depth. You see, and it doesn't mean that just because the person drinks one glass of alcohol, it becomes a total idiot. As compared to a person who drinks a bottle. So you see, you cannot paint everything with one brush, with the same brush.
My lord.
You could have been drinking one glass, or two glasses, or three glasses, you do not know. But you could come home, you could walk home, ask for money, have the senses to ask for money, and not be happy with the amount that you. It was not that you were totally out of your depth, or totally not knowing what you were doing.
But the same test was also applied here, my lord, in Nipam Fukan, my lord.
Never forget there was total strangers. The reaction
No, so far as intoxication is concerned, my lord.
out there was slightly different. You have to
Because the standard of intoxication, my lord, in Nipam Fukan also, my lord, is somewhat similar to this situation, my lord.
but then they out here their own mother and their own uncle. Out here they're total strangers. And they were out on the street. They were those
Inside house.
intoxicated persons were out on the street. Here it's inside the four walls of your own house.
Yes.
So you see, if they're supposing, let us say, supposing you have a son who is a total drunkard, and he makes noise outside the house. And on the other hand, there is a total stranger who is totally drunk and makes noise outside the house. How are you going to treat them? Will it be same treatment to both of them?
Certainly not, my lord.
So similarly, if the son, when he sees you, though he's intoxicated, his reaction will be different. But if the stranger is there and he sees you and you abuse him or whatever, his reaction will be totally different. We have got to think of, I don't know, we're just thinking aloud because there's so many situations and circumstances that can change the complexion of how things have to be looked at. Huh? We'll see. Any other judgment? These two judgments.
My lord, on
It's
this
basically
aspect, my lord,
this
kindly
case
allow
has-
me one more day, my lord. I will,
No,
one more day, my
we
lord.
wasted time. You know.
Just,
In fact, now, did you read Supreme Court is now giving time clock to the lawyers?
but
You
so far as
complete your
the
argument. You should have.
intoxicated state is concerned, my lord, I will come back, my lord, with that homework, my lord. So far as,
You come back with the homework, no problem. We will have it CAV. We will keep it CAV. You give us the citation by tomorrow. So that let us do our work. You see, there are numerous persons. We have a duty to do work also, and we have got a duty to also help us do our work.
my lord.
And it is not your case that you wanted adjournment and we didn't allow it.
Yes, yes.
It was your case that we should finish the case. We have heard it. Now you want to do some more research work after hearing you. That is not that. Otherwise, what will happen? Cases will never end. If we keep on adjourning, you all will say, these two judges, they only to hear, they never dispose of any matter, only wasting time, time wasting tactics. You got to think of us also.
Lordship, I have given judgment of single eyewitness. Lordship, I have given.
He's not on the
He
issue
is
of,
the intoxication.
he's on the issue of exception 1 or 4. 1
Lordship.
and 4. 1 and or 4.
Lordship.
That's all. So he wants that it should be under 304 part 2.
Part 2, because he's in. Lordship.
So according prima facie, it appears to us that it can be either 302 or 304 part 1. we will see whether 304 part 1 can come into that one. If it doesn't, then we'll have to go to the next forum, higher forum. Yes, which forum?
Lordship, para 22, Lordship. 21, Lordship, 21.
This is all right. This is with regard to,
Lordship,
with regard to quality of evidence, we're not on that.
Lordship,
There is no-
provocation
there
and
is no
Lordship,
dispute
Lordship,
with regard to the fact that he killed his brother.
Lordship, provocation
The fact
and
is whether
provocation is there.
302 should be applied or
Or
304,
304.
304 part 2. 43.
Yes, madam.
That's all.
But so far as my case is concerned, my lord, in my respectful submission, I am squarely covered under say exception 4, my lord.
You see, what we can do is we'll keep it savvy for you.
Yes, ma'am.
But you give your judgments to us by tomorrow or the after. You can give it to him. We'll
Yes,
just
yes,
look at it. What you can do is you give a note.
My lord. I've already given a note, my
Number
lord.
one.
Yes,
Case number so and so, the paragraph that you want.
my lord.
Okay, just you-
Right.
And just in the small heading, one line, what is the issue
Yes,
that you want to highlight by way of this? That's all.
yes, yes.
That's all you're going to do. Anyway.
Yes, yes.
Anytime. By when can you give?
Madam, day after tomorrow.
Day after tomorrow. Okay, by day after tomorrow. Then we will have to pronounce it after the vacation.
My lord.
Because we have got to,
My lord.
we don't want to put it parted or, list it for some other day.
My lord.
Because we will get into the habit of doing that. Correct. Right, Mister?
Yes, that's my lord.
Yes, that's it. Learned counsel, legal aid or?
No, my lord.
Yes. The learned counsel for the appellate. Also heard Miss Abigail, learned APP. This appeal has been filed against the impugned judgment dated 13/7/2018, passed by the learned session judge Kamrup M. Guwahati in sessions case number 42/2016, by which the appellant has been convicted under section 302 IPC for killing his mother with a sharp-edged weapon. Bracket, what is the name?
Botidao.
Botidao.
BOTHI.
Which is used for cutting vegetables
My lord.
and
And other item, fish and
cutting vegetables and fish, etc. So that in a nutshell is the case. Next. The appellant's counsel submits that there is no denial with the fact that the appellant had killed his mother. What? There is denial. You tell us.
No,
No, you have-
Lordship.
No, just not you,
Mhm.
his subject. You have to tell us your point, because that is what you have been saying.
Yes, yes, my lord.
If
So
you are
far
not
as-
saying that,
no, my
then we'll make it an issue, that's all.
yes, my lord. So far as 313 is concerned, my lord, there is a complete denial. But so far as the prosecution case is concerned,
no,
even
we-
assuming, my lord, this
you
is my
see, you-
alternative argument. Even if the prosecution case is taken to be true and correct, even then, I am on the proportionality
Okay.
punishment.
Whatever I said, the learned submits that that
313 is totally not denial, Lordship.
Huh?
In 313, It is not totally denied. Question number 4 and question number 5.
That's why, so he's only denying on 11, 12 and 15, that's all. No evidence also. We'll have to, but then it, okay, well, okay, submit, so the appearance counsel submit that his challenge, that the appearance challenge to the impugned judgment is firstly on the ground that the appellant did not kill his mother. In this regard, he has relied upon the explanation / answer given by the appellant in his examination under section 313 CRP to question number 11, 12 and 15. The alternative challenge made by the appellant to the impugned judgment is that even though the evidence of PW5, even though the evidence of PW5 and 7 appears to prove the fact that the appellant had killed his mother, correct? Correct. The conviction of the appellant could not have been done under section 302 IPC. Inasmuch as there was no premeditation and intention to kill the mother. The act of killing the mother had been made due to a grave and sudden provocation.
Under the influence of alcohol.
Under the influence of alcohol. And as exception 4 or 3,
Madam, 4.
exception 4,
Four.
it has exception 4 to section 300 IPC was attracted to the facts of the case. The charge under section 302 IPC should be altered to section 304, part 2.
It's conviction, man. Conviction.
The charge has to be altered. Thereby conviction, whereby conviction could only have been made under section 304, part 2 IPC. He does submit that when the evidence shows that the death of the mother had started from a grave and sudden provocation which resulted in a fight, resulting in the death of the mother. The complete chain of events would have only led to the conviction of the appellant under section 304, part 2 at best, and not under 302 IPC. That's all. In this, in support of his submission, that the respondent, no, the appellant was not could not be said to be a reasonable person in the ordinary sense of the term, as he was intoxicated. thereby attracting exception 4 to section 300 IB. He has relied upon the division bench judgment of this court in the case of Nipam Fukhan alias Petai versus the state of Assam. Criminal AJ, A bracket J, 91 of 2009. Wherein it has been held at para 46 as well. Next para. The learned counsel for the appellant further submits that the Supreme Court in the case of Vijay alias Vijaya Kumar versus state 2025 3 SCC 671. Has you see has laid down the test to decide whether a certain provocation was grave or not. Which is whether a reasonable man was likely to lose self-control as a result of such grave provocation. He submits that para 22.2 of the such judgment has para 22.2 and 22.3 of the said judgment has clearly provided the objective test to be applied for deciding the said issue. On applying the said test to the facts of this problem. Wherein the deceased mother had given 2 slaps to the appellant when there was a sudden fight between the appellant and the maternal uncle
PW7.
bracket PW7 of the appellant, comma. The only answer that would come out would show that the provocation made by whom?
PW7 and the deceased.
Made by the PW7 and the deceased was grave. Comma for which provocation and fight made by the for which exception 4 to section 300 would be attacked. He does submit that the impugned judgment will be set aside and the appellant should either be acquitted of the charge under section 302 IPC or in the worst scenario, Mahesh will be convicted under section 304 part 2. I think.
Look.
Miss Abing up additional PP for the statement, comma, on the other hand, submit that that PW
5,
is the eyewitness
eyewitness.
to the fact of the appellant killing his mother with the what, dhoti?
Boti,
Boti?
Boti Dao.
The boti da. Which nearly severed the head of the deceased.
Neck,
Which
neck.
nearly severed the neck of the deceased. Anything else?
Lordship, culpable homicide becomes murder if the attacker caused by knowing that it will be harmful to her and she may die.
Anything else?
There is
He
some-
submits that when there is an eyewitness to the crime in question. The fact, the stand of the appellant that he had not committed the crime. Has no legs to stand on. Further, in the case of Veer Singh and others versus state of Uttar Pradesh, from 2014 to SC 455, the Supreme Court has held that it is not the number of witnesses, but the quality of the evidence of the witnesses which is important. And there is no requirement under the law of evidence that any particular number of witnesses is to be examined to prove or disprove the fact. The evidence must be weighed and not counted. Further, as a general rule, a court can act on the testimony of a single witness, provided he is fully reliable. In the present case, when there is no ground to take a separate view with regard to the killing of the deceased by the appellant on the basis of the evidence adduced by the eyewitness PW5 and the maternal uncle of the appellant PW7. The conviction of the appellant under section 302 IPC suffers from no information. The learned APP further submits that exception 4 to section 300 IPC is not attracted to the facts of this case. Inasmuch as the provocation had been initiated on the part of the appellant and not by the deceased or the maternal uncle, bracket PW7. Further, the alleged retaliation by the applicant, by the appellant by nearly severing the neck of the appellant, deceased. In response to the deceased mother slapping the appellant twice when the appellant and the maternal uncle were fighting. Comma does not attract exceptions 4 to section 300. Accordingly submits that there is no ground to interfere. Which here does not only submits that the learned transfer, the dispute judgment of the learned transfer should not be interfered. That's all. That's all. We have heard the learned causes for the hearing concluded, no, you right, hearing concluded, judgment. This we take separately.
With that note, my lord, submit.
Yes,
After
yes.
that may be reflected in the order.
Huh?
Or reflected in the order.
Give it to
Okay,
him
ma'am.
separately. We have made it CV.
My,
But you make a index type,
my lord.
how many judgments, 1, 2, 3.
My lord.
Number one, the case number. Okay, then number 2 column, number 3 column, you put the paragraph that you want. And one small line with regard to what is the point you want to
My lord.
read. Okay.
My lord.
Obviously.
Deeply okay.
Fine.
Quite please, Your Lordship. Your Lordship, in this matter, on the last occasion, we were about to ask for the TCR copies, but from the office, we got to know that until and unless there is specific direction from the court itself, they are not ready to provide the TCR copies to the
Well,
advocates.
you need paper books, madam.
For the cross case, Your Lordship, the
there
TCR
is a
copies,
case.
yes, Your Lordship.
There's a cross case.
Yes, Your Lordship.
So cross case is a different set of evidence,
Yes, Your Lordship.
huh?
Yes, Your Lordship.
Different evidence was taken.
Yes, Your Lordship.
You are the convicted person.
Yes, Your Lordship.
You
And in the other
are in which case? You are in 18 of 22.
22.
18 of
Yes, 18. Yes, 18 of 22.
18 of 22 is your case.
Yes, Your Lordship. And this
And where is the acquittal?
acquittal is in the cross case, Your Lordship.
What is the cross case number?
The cross case number is FR Sessions case 158 of 2016. Cross case to copies, I will say. Liquid revision, but I'm not copy number media officially. Yeah. Case to number, Ami Tate complainant.
Why did you make such a reply earlier? Well, such a statement earlier? You have only asked for adjournment all the time. For the last,
Yes, Your Lordship.
huh?
We tried to take it from the office, but we were told that won't be provided because this arises out of the same incident, Your Lordship, and we are the complainant in that case, Your Lordship. Yes,
You are the complainant in the other case.
yes, Your Lordship.
So,
So the TCR copies,
you see, madam,
yes, Your Lordship.
a cross case,
Yes,
when there are two cross cases,
yes, Your Lordship.
the evidence in both the cases have to be led separately.
Yes, Your Lordship.
Okay. You cannot use that evidence here.
Understand.
Then a decision in a cross case will have to be based upon the evidence led in that cross case, not on the basis of evidence that is led in this case. Even though the evidence might be the same, the evidence have to be read separately. So why do you want the evidence of the cross case? That was never your prayer in any earlier day.
My senior on the earlier date talked about this and it was told that we can seek for the copies, but from the office we were told that as an advocate.
Where is your application to the authorities, to the registry, asking for copies of the property?
We have inquired, Your Lordship.
Where is your application, madam? There's a difference between inquiry and applying for it.
I do not have that application, Your Lordship.
That is just an excuse you're delaying the matter. Is it on, you see, this matter is being listed time and again,
Yes,
being adjourned time and again. Do you really want to dispose of this matter or you
No,
only
no.
come here for appearance?
no, Your Lordship, we want to dispose the matter.
Then you apply.
Okay, then we will apply and if there is anything, we will let the court know. Because no, Your Lordship, my words
You will
might
let us
be,
know.
my words might be a little bit different, but we will apply and
Where is the
because-
senior? Where is the senior?
he's on legs, Your Lordship.
Tell him to come.
Lordship.
We clarify. We give you one more date. This is item 5, no?
Yes, Your Lordship.
Eyewitnesses are there to the crime. That is why you are not wanting to do this matter.
I'll let him know. If there's on one date may be given.
No date. You ask your senior to come.
Okay.
Otherwise, we will take a stand that he is not interested in pursuing the matter. We'll engage our legal aid now.
I'll let him know.
Item 7.
You're ready, madam, now?
Yes, ma'am.
Okay, then we can.
Jashodi, this lordship, item number 7, someone may be appointed, is no more.
What happened? Why?
Item 7 is no more, my lord.
Who is that? Oh. Item 7, okay. Right.
So,
Miss B. Bhuyan, additional PP appears for the state and submits that the amicus curiae, Mr. Jeda, has expired. If that was the matter, a new amicus would have to be appointed in place of the deceased litigation. Sir, Tiwari. Mr. A. Tiwari. Amicus, there is appointed as the amicus curiae. Registry to provide a copy of the paper to Mr. A. Tiwari. This is the matter for hearing.
Any demand?
You office of code?
After receipt of the paper.
After?
If I receive the paper.
You were dead.
Does not even say about that part only. The PM report only says that brain matter came out.
Made so many bullet points. Give us a list of your bullet points.
My lord, I have, my lord, only, my lord, last night since I prepared, my lord, because I was not in station, my lord. only.
Okay, no problem. Then,
So, my lord, to my very understanding and that part, my lord, the
okay.
Caesar list, my lord.
Those bullet points are there.
Yes, ma'am.
Now there is one query we want to put to you.
106. ma'am.
The thing is that 106.
Now, my lord,
Is it your case that you were away from the house at that
Yes.
time?
my lord, 313, the last answer was that when I came to home, I found my husband dead.
Dead.
And I informed the Gaon Buddha
When did you go home? What time?
at around 5 in the evening.
At around 5 in the evening.
Yes, my lord.
And he was already dead at that
He
time.
was already dead.
And you came home from where?
From the Bagan, my lord, because I'm a
From-
tea garden laborer, my lord.
From the Bagan. And what was he doing in the house alone? Cooking?
No, my lord, that part has not come in the evidence. That part has not come in the evidence. What was the husband doing at the home? That part has not come up in the, because, my lord, it is the prosecution. Even the prosecution have proved the case beyond reasonable doubt. Then, my lord, 106
But
explanation.
then the question is, you're the wife.
Yes, my lord.
You don't expect the girlfriend to be living in the house.
That's correct, my lord.
Now, when you left in the morning
Yes,
to
ma'am.
work in the Bagan,
Yes, ma'am.
was he in the house?
No, that part, my lord, he would obviously be at house, my lord.
I don't know. We do not know.
But,
We
my
are
lord, that has
asking
to
you.
be brought by the prosecution, my lord.
Arre,
That question was not.
Does the police stay in your house?
No, but my lord, in 313, that question has to be put by the prosecution to me, my lord. That was not put on to me, my lord. So I did not answer to that, my lord.
Okay, so that then what else?
And my lord, the firewood alleged to be said to have blood smear, my lord, that was not sent for serological test also, my lord. So, my lord, these are some of the vital aspects, my lord, which are missing in this case, my lord. My lord, page 1, your lordship would find the date of occurrence is my lord, page 1, my lord,
Page 1.
column number 3, my lord. The date of occurrence is shown to be 21/01/2018 at about 7 in the evening, my lord.
Yes.
And the information is received on the next day on 22/01/2018, time 10 a.m., my lord.
So what is wrong?
No, my lord, I'm just showing that part, my lord. 10 a.m. It's 10 a.m.
It's 10 a.m.
It should be 10 a.m. It should be 10 a.m. my lord. Now, HR is at page 4, my lord. The informant is a co-villager. May I read, my lord? Humble submission is that around 7 p.m. on 21/1/18, a quarrel took place between Mohan Karwa and his wife. The above mentioned accused person, following that quarrel, the said accused Mohan Karwa's wife assaulted Mohan Karwa in the head and in the face with a split firewood, as a result of which Mohan Karwa died. A case under 302 was there, man. Now, my lord, the charges were framed, my lord, under 302, my lord. That is at page 6, my lord.
Yes.
Then, my lord, the informant is PW1, my lord. Now, in the chief, he says, but in the cross, he denies everything. May I read, my lord?
Yes, yes.
I am the informant of this case. I know the accused. I knew the deceased. He belonged to our community. About 1.5 years ago, the occurrence took place. On the date of occurrence, at about 5:30 in the morning, I had heard the children of my neighborhood discussing that previous night during a quarrel between the accused and her husband, the accused committed murder of her husband. Then I rushed to the house of the deceased. The house of the deceased is situated passing 3 houses from my house. In the house of the accused, I had seen the accused sitting on the doorway of her house. Inside the house, I found the dead body of deceased Mohan Karwa in a sitting position, leaning on the wall of the house. I had seen the bleeding on the head of the deceased. The blood on the injury on the head of the accused has already clotted. In the house of the deceased, there was no other person except the deceased and his wife, accused Lakshmi Karwa. I had found about 4 or 5 minor children in the house of the deceased who were from his neighborhood. near the dead body of Mohan Karwa, I had seen one piece of firewood.
Just a minute, in the house of the deceased, there was no other person except the deceased and his wife. Okay,
Yes.
yes, continue.
Near the dead body of Mohan Karwa, I had seen one piece of firewood. Deceased neighbor Sunil Tati also came to the place of occurrence. I asked him to inform about the incident to our Gaon Buddha. Then he went to the house of the Gaon Buddha and informed him about the incident. Later, Sunil came back and told me that Gaon Buddha has advised us to inform the police. Therefore, I informed the police of Dimakuchi PS over phone. Later on, police came and took the dead body to Udalguri Civil Hospital. The accused was arrested by the police. Later on, I lost the FIR. Exhibit 1 is the FIR. Exhibit 1 is my signature. The police has seized the firewood which was found near the dead body of the deceased Mohan Karwa. Exhibit 2 is the sizzle list. Exhibit 2-1 is my signature. The magistrate conducted the inquest of the dead body. I had put the signature in the inquest report. Exhibit 1 is the piece of firewood seized by the police. Now cross part. The house of Panda Munda, Bokan Munda and Mercy Munda are situated between the house and the house of the deceased. Now only Panda Munda was examined, my lord. These Bokan and Mercy were not examined in this case. The accused is a temporary labor of Bamunjuli Tea Garden. I cannot say who had written the FIR. The contents of the FIR were not read over to me. It is a fact that I did not state before the police that on the date of occurrence at about 5 to 5:30 o'clock in the morning, on hearing the discussion of the children of my neighborhood, discussing that previous night during a quarrel between the accused and her husband, the accused committed murder of her husband. I rushed to the house of the deceased. So this part is denying that he did not state before the police in the 161, my lord. It is a fact that I did not state before the police that in the house of the accused, I had seen the accused sitting on the doorway of her house, and inside the house, I found the dead body of the deceased Mohan Karwa in a sitting position leaning on the wall of the house. Police had seen the dead body of Mohan Karwa leaning on the wall of the house. It is a fact that I did not state before the police that I sent Sunil Tati to the house of Gaon Buddha, and he told that Gaon Buddha advised us to inform the police and accordingly. So, my lord, entire part he has denied, my lord. Because these were not stated during 161, my lord. Now, my lord, last above 4 lines, my lord. The firewood like seized firewood are available in our nearby area. I do not know whether the accused killed her husband or not. She herself confessed that during quarrel she assaulted her husband, but she had not intended to kill him. I cannot recollect as to whether I had stated before the police that the accused confessed that she killed her husband. So, my lord, this has not come from the witness to the police that she made an extrajudicial confession, my lord. So, my lord, from this part, my lord, it cannot be said that there was, because he did not state before the police that she made a confession, my lord.
He confessed before this is private person.
No, my lord, this person did not say the 161 statement, because this has to be brought from 161.
No, but this was not stated in his examination in chief. It was asked. This question was put in the cross-examination.
No, my lord, he has stated.
This is a cross-examination part. You brought out the damning evidence against yourself.
But other way around, my lord.
Other way around.
But he has not stated in the chief, my lord. If some mistake is done by my lord counsel, my lord, that cannot be inferred to the.
No. When you want a clarification, why did you ask this question? This was not at all stated by him in his examination.
Correct, my lord, correct.
Why did you ask him this
My-
question? You should not have asked him the question.
My lord, sometimes, my lord, some counsels go beyond what is there
Yes.
required, my lord. They should know where to stop, my lord.
Yes, they should know where to stop.
Stop.
Unfortunately, they have not.
They have not.
They're digging their own grave.
Now, my lord, PW2, my lord. This is the BDP secretary, my lord. Is not the Gaon Buddha. Sri Sankar Sonari. I know the informant and the accused. Page 10, my lord. I knew the deceased Mohan Karwa about 1.5 years back. The occurrence took place on the date of occurrence about 6 to 7 a.m. while I was at my house. Guddu Karwa of my village went to my home and informed that Mohan Karwa was killed by his wife Lakshmi Karwa. But my lord, in Gudu Karwa's evidence, chief my lord, it came that he sent Sunil Tati. Now here he says that it was Gudu Karwa, the informant, who came to his house. At the material time, I was VDP secretary of our village. Therefore, I went to the place of occurrence with Gudu Karwa. In the house of Mohan Karwa, I found the dead body of Mohan Karwa in a sitting position, leaning on the wall of his room. The police has already arrived at the place of occurrence. I found on the face of the deceased, I found blood on the face of the deceased. The accused was sitting at the threshold of the door of the room. I had seen 2 pieces of blood-stained firewood lying on the ground near the accused. There was gathering of people. On being asked by the people, the accused told that she assaulted her husband by the 2 pieces of blood-stained firewood. The police seized the 2 pieces of firewood. Exhibit 2 is the scissor list. Exhibit 2.2 is my signature. Now, my lord, cross part. My house is 1 kilometer away from the house of the deceased. There were houses of many people on the road from the house to the house of the deceased. I had to cross a river to reach the house of the deceased. It is a fact that I did not state before the police that while I was at my home, Gudu Karwa of my village went to my home and informed that Mohan Karwa was killed by his wife Lakshmi Karwa. It is a fact that I did not state before the police that in the house of Mohan Karwa, I found the dead body of Mohan Karwa in a sitting position leaning on the wall of his room. The police was present at the place of occurrence and they had seen the position of the body. When the accused confessed her guilt before the village, I was not present at that time. Nobody except Gudu Karwa went to the house of the deceased along with me. The house of Panda Munda and Jiten Tati are situated near the house of the deceased. It is a fact that I did not state before the police that there was blood smear on this seat where I was present. I alone went to the place of occurrence. There were more than 50 persons at the place of occurrence. I cannot say their names. When I put my signature in Exhibit 2, the police did not read over the contents of Exhibit 2 scissor list to me. I stayed at the place of occurrence for about 15-20 minutes. After putting my signature in the scissor list, I left the place of occurrence. I cannot say the exact time when I put my signature in the scissor list. I had not seen the incident. But here he says that he did not meet the VDP secretary, my lord. Because he is one of the well-known persons there, my lord. He also did not state that he find the informant there, my lord. But he says that there were 50 people around, my lord. Now PW4, my lord. He is also a co-villager, my lord. Jiten Tati. I know the accused and the informant. I knew the deceased Mohan Karwa about 1.5 years ago. The occurrence took place on the date of occurrence in the morning at about 7 to 8 a.m. While I came out from my house, I saw the people running through the road raising alarm that Mohan Karwa had died. I then went to the house of the deceased where I came to know that Mohan Karwa was killed by his wife. I had seen the accused outside the house sitting near the door of the house. The dead body of Mohan Karwa was inside the house in a sitting position leaning on the wall. I had seen the bleeding injuries on the face of the deceased. The firewood with which the accused assaulted her husband were lying on the ground near the accused. Police has seized the firewood through Exhibit 2 scissor list. Exhibit 2.4 is my signature. M exhibit is the piece of firewood seized by the police. Cross. My house is about 150 to 200 meters away from the house of the deceased. I cannot say the names of the persons who were raising alarm on the road. It is a fact that I did not state before the police that I had seen the dead body of the deceased in a sitting position leaning on the wall of the room and that the piece of firewood with which the accused assaulted her husband were lying on the ground near the accused. At about 8:30 to 9 a.m., I went to the place of occurrence. The contents of the scissor list were not read over to me by the police. I had not seen the accused killing her husband. Now, my lord, PW5 is the woman sub-inspector, my lord, who conducted the investigation, my lord. But prior to filing of the charges, she was transferred, my lord. And PW6 is the sub-inspector, my lord, who filed the charge sheet, my lord. Now, his part is PW5, I'll read, my lord. On 30/11/18, I was working as the officer in charge of Dima Kuchi PS. On that day, I received the case diary of the instant case from the investigation officer, SI Maheshwar Sharma. Upon perusal of the case diary, I found that investigation of the case has already been completed by the IO except collection of postmortem examination report. Hence, I collected the postmortem examination report of the deceased and submitted the charge sheet under 302 against the accused Lakshmi Karwa. Now, my lord, Maheshwar Karwa, the SI who investigated the case, my lord. PW 6, my lord. On 22/1/18, I was posted as officer in charge of Dimakuchi PS. On that day, Guddu Karwa lodged an FIR before the officer in charge of Dimakuchi PS. Basing on the FIR, I registered a case being Dimakuchi PS case number so and so under section 302 and myself undertook the investigation. I immediately rushed to the place of occurrence, which is number 1, Bulatat. The police, the local people of that place told me that accused Lakshmi Karwa killed her husband, Mohan Karwa, by means of firewood and showed me the dead body which was lying inside the house of the accused. I found the accused outside her house and she showed me 2 pieces of firewood by which she assaulted her husband, as a result of which her husband succumbed to his injuries. I recorded the statement of the informant as well as the witness available on the place of occurrence under section 161. I prepared the sketch map of the place of occurrence. Then I shifted the dead body to Dimakuchi PS. The inquest was held on the dead body by the executive magistrate. The dead body was sent for postmortem examination. I seized the 2 firewoods from the place of occurrence on being produced by the accused. Accused was taken into custody and forwarded to court. In the midst of investigation case, I was transferred to Bayhata PS and as such, I handed over the case diary to my successor, WSI Nilima Burma. Now, my cross. I recorded the statement of the witness at the place of occurrence. I have not cited the executive magistrate Rituban Bora who conducted the inquest on the dead body as witness of the case. I seized 2 pieces of firewoods at 11 AM on 22/1/18. I did not send the seized firewoods for FSL examination. So, my lord, once a blood smear is there on the, my lord, alleged weapon, my lord, if I take, my lord, then, my lord, at least that, my lord, weapon should have been sent to for serological test, my lord. This was not done, my lord. Because, my lord, why it is required? Because, my lord, the case rests on circumstantial evidence, my lord. If, my lord, circumstantial evidence is involved in a case, my lord, in that case, my lord, the weapon in the offense, my lord, has to be sent for serological test, my lord. Because the prosecution has to stand on note fitting that it was none other than the accused who has inflicted the blows, my lord. Now, my lord, this is very important, my lord. PW7, my lord, the doctor who conducted the autopsy. Now, in this, only he says fracture of skull. And, my lord, second, my lord, brain matter is coming out from the head and head injury. Bleeding from the left ear. Now, my lord, what weapon used in the assault?
You could have asked that question to him. Did you ask?
My lord, if there is a seizure of a firewood, my lord, and my lord, if I put on a question, my lord, and if he says that yes, it was a blunt and a heavy blunt, then, my lord, I am otherwise making a
Well, but you are not denying that these injuries were there.
well injury. Why should I deny? Because I'm saying in my 313, I have not killed, my lord. Then why should I deny the injuries, my lord?
Mr. Tiwari,
Yes, ma'am.
what were you doing on the Sunday or 5 p.m. after as per your group statement? Because you came back at 5 p.m.
Yes, ma'am.
We found you on after night there. What were you doing the next morning?
My lord, this is what, my lord,
Doing with the body have
my lord, in my 313, I have said that I have informed the Gaon Buddha, but they did not came, my lord.
okay. What were you doing?
But, my lord,
The captain, the Garuda, the
but, my lord, the PW1, apart from that, also says that I have heard from the childrens that last night there was a quarrel. So even otherwise, if it is that part is taken care of, my lord, then their fathers and the other family members, also nearby persons, have also heard about the quarrel. So they should have gone there, my lord. But this is not the case.
You died in the house. You
Yes, my lord, that, my lord,
got it. We did.
this is absolutely correct, my lord. This I
Yes, what remains? But out here, it does not make it feel there were police. There was mistake. But here, he might have confessed 2-3 times. But remember, he's the first to read.
That explanation which has come from your lordship, my lord. That explanation, my lord, had I given that explanation, my lord, I could have been out of this case, my lord. That explanation from last evening to second morning, being a wife, I was there at the house, but I did not inform anybody, but only a blood statement that I informed the Gaon Buddha. But had that been evening, the people would have gathered after her information and things could have been different, my lord. But my lord, around my lord, saying 10 hours or 8 hours, I was sitting silent. I was in a shock, my lord. That, my lord, is also, my lord, was striking on my mind, my lord. But otherwise, my lord, whatever I could, my lord, bring out a case, my lord, I have placed that part, my lord, because, my lord, it is VDP secretary who has been examined, but the Gaon Buddha has not been examined. And had the Gaon Buddha been examined by the, yes.
Your key, your 20.
These are some of the parts, my lord, which the trial lawyers should take, my lord. But once she said that in 313 that she informed the Gaon Buddha, he could have taken an individual to call the Gaon Buddha on the dock, my lord. Had he brought the Gaon Buddha on dock, my lord, if that part would have been proved that yes, yesterday evening she informed me about that, then things could have been different. Because here only by this statement, my lord, my 106 explanation should have been there, my lord, which is not there.
Because this confession given by PW1, by the appellant, to PW1 is in the absence of the police. He was the first to read.
That I have asked in my cross-examination, but in the chief, he did not say about that. And my lord, most interesting part is that the lawyer who conducted the trial, my lord, in the argument, he took the ground of 300 part 4, my lord, that there was sudden provocation, which I'll just place, my lord. My lord, to kindly see in the judgment, internal part, my lord, page 28, my lord, para 12, my lord. His case in the learned trial court was that since there was sudden provocation from her husband and he assaulted her.
Para 12.
Para 12, my lord. Page 28.
Okay.
Page 28, my lord.
Wait. So he has admitted.
Well, this is what in the argument, my lord, it has been brought. And my lord, now lordship would see the trial judge has, my lord, also recorded certain parts, my lord, at page 42, my lord, para 34, that they are garden people's. This part, my lord. May I read this?
Yes, yes.
True, it is that the accused and the deceased are garden laborer, and on the day of incident, as stated above, there were none in the house except the husband and wife. So when the quarrel took place between the husband and wife, the wife assaulting her husband on his head with firewood out of anger or under the influence of alcohol, causing his instantaneous death as a consequence of the injuries sustained, is a natural corollary. It is to be noted that most people in the tea garden life is still lagging behind from proper education and other basic amenities of life as against the successive governments. Much exclaimed all-round development touching all society, section of the society. The tea garden life is admittedly precarious because of the lack of education and understanding between the husband of wife. Conjugal life is full of deficiency, lack of compassion and true love as they live a routine dull life. After days hard work in the garden in the evening under the little influence of alcohol, it is the life circle. They quarrel even in the smallest of things in a fit of rage, aggressive attack without thinking much about its consequences. They live in very narrow confines because of lifestyles they accustomed to. So, my lord, if that part is taken, then my lord, sudden provocation and this part can be brought into it, my lord. Because 7 years, 11 months, she is behind the bar.
There is no evidence to have made this observation.
Yes, ma'am. That part is not there. Ma'am. Neither that was brought.
The trial court could not have gone into such observation on its own.
So, my lord, this is where, my lord, my humble submission is that first part, my lord, the motive behind the killing was not brought by the prosecution. That is missing, my lord, in the entire case, my lord. My motive. Second part is that, my lord, they should have at least brought a previous enmity or a regular quarrel in order to show me killing. Because, my lord, it is an admitted position that the incident happened 1 day prior. Only, my lord, since my 106 explanation and not examining the Gaon Buddha to whom I have informed, my lord, that cannot be fatal to my case. Third part, my lord, weapon of assault not sent for
All their arguments would have been fine. Except for that cross-examination. That has not been explained.
But my lord, section 24 also says that if otherwise I am in the custody of the local peoples or in the police, whatever statement I make, my lord, that cannot be.
Well, just come to this evidence of PW1. He is the first one on the scene.
Yes, he is the first one on this side. Nobody will like it.
Now, one person came later on. And then PW1 informed that person to inform the Gaon Bora. And then they inform the police.
But the VDP secretary, even if it is taken as a Gaon Buddha, my lord, he says that it was the PW1 who came, not the Sunil Tati came. Because PW1 says that he sent Sunil Tati, my lord. Kindly see, my lord.
No, you see, but PW1 is this Gudu Karwa.
Yes.
Gudu Karwa is the first person who went to the house. He says here.
And thereafter Sunil Tati.
Thereafter Sunil Tati, deceased neighbor Sunil Tati also came
To the place over. I asked him to inform about the incident to Gaon Buddha.
I asked him to inform about the incident to our Gaon Bora.
But now Gaon Buddha says, my lord, in PW2, my lord, he says that Guddu Karwa, the informant, came to his place of residence. But even otherwise, he is to be taken as in Gaon Buddha only.
That case, then he doesn't say that from during the night.
Yes.
If you just speak one, speak less, then you are in front of the
Gaon Buddha. But my lord, he is not the Gaon Buddha, my lord.
Not victim. This is Anything else?
But my lord, the IOD never says that she made any extrajudicial confession to him also. That part is missing in the PW6, my lord.
Actually, there's no denial of the fact that she made it to this PW1. And it was unearthed by you, no one else.
Yes, ma'am. But sometimes, my lord, we need to know what to ask, what not to ask, where to start and where to stop, my lord. These parts, my lord, have made and that apart, my lord, at least, my lord, there should be some trainings, my lord, because in most of the matters that I've seen there, my lord, question are asked beyond whatever is required.
Whatever is required.
And that may creates a problem. And my lord, generally in all the trials, what I've seen is that man, they don't even try to adduce any, even if they have taken a plea of LEB, my lord, they don't try to bring on the person concerned in the doc as DW to place that part, my lord. To
Ah.
substantiate that the plea of LEB is there. They don't even bring that part, my lord. That, my lord, that problem is there. Rest, my lord, otherwise, my lord, there are judgments, my lord, which says that if case of circumstantial evidence is there, then serological test is very much required.
What test?
For serological test, my lord. That part, my lord. Second part is that, my lord, even if 106, my lord, explanation would come only, my lord, this Anish judgment, recent Anish judgment, well, I have only one copy of this, my lord, Anish judgment, well, I'm extremely sorry. But my lord, this judgment says that if the prosecution is otherwise able to prove the entire case, then only, my lord, the 106 explanation from my end would be required, my lord. That part is there. Because if they are able to prove all other matters.
Para.
My lord, I'm extremely sorry. It was only one copy with me, my lord. In the next one. It's my list card. It's my list card. See. List card.
Para 50. Out here, the different facts,
Facts are different.
the different facts, they complement each other in because the confession is there. That is the confession read with 106, read with your 313. Of course, they're all weak evidence, but then taken as a whole, they form a complete chain, it appears. Anything else?
No, man.
has come up from the mouth of the witnesses, my lord, this accused person and the deceased used to live together. Only they were there in the place of
It is
occurrence.
not disputed, they live.
No, Lordship. And one of the circumstances, your Lordship, PW 1 page 8,
Yes,
Lordship, the blood on the injury on the head of the accused had already clotted. Might have been deceased, my lord, I don't know. Lordship. If she has caused the injury, splitted, maybe injury was, Lordship, blood was there on her head, my lord. It was already clotting. The blood on the injury on the head of the accused had already clotted. That is there, my lord. And Lordship,
so what does that imply?
she has committed the
It has
crime.
been for some time, it's been dead for some time. That's what it-
No, no, not for that, my lord. If the blood, the stain was there on the head of the accused person, she was very much involved. It is there. The witness didn't say it was on the part of the deceased. It says on the head of the accused, my lord, had already clotted. Lordship, it has been between injury on the head of the accused is already clotted.
So basically, you're trying to say that he had been dead, that he had been dead for some time.
No, no.
To have
I'm trying
clotted.
to- No, no. It is clotted.
In the house of the accused, I think the accused sitting on the door in the house, he said that I found the dead body. I think the bleeding on the head of the deceased, the blood on the injury on the head of the accused. It should be deceased. There
Maybe,
cannot
my
be,
lord.
there was no injury on the appellant.
It has not come up in the prosecution evidence, my lord. But if she has committed since she has committed the crime, lordship, it like, yes, pelto, and it was clotted. Lordship is aware of sometimes blood is seen under costumes wearing apparels of the accused person also.
What is the
Clotted
word?
because
What is- What is the word? Okay, so some of the blood had.
Yes, already there it is clotted.
Ah.
And your lordship, no, like, she has not taken any steps. If she has discovered the person dying or is injured condition, no steps have been taken, no endeavor from her side.
No, no, madam, but.
My lord,
It is the blood on the injury.
On the injury.
on the injury,
On the head.
of the, but
There
it's
there
written
was
as
no injury
accused.
on the lady.
Maybe, nice.
It should be diseased.
Disease, my lord.
Injury was not there on
It
the.
has not come up in the evidence that she was injured. It may be read otherwise, your lordship.
Cannot be read otherwise. How can we read otherwise?
Lordship,
Where is your case that she was injured?
no, she was not injured.
There was a
Lordship,
fight both ways.
the blood which is come out due to injury, it was like it spilled over her head. Even otherwise, my lord, the conduct of the accused person, subsequent conduct, is a circumstance which can be taken into account, my lord.
Why? What happened? What did this happen?
She has not only she said that she has reported the Gaubura, but nothing, my lord. She could have called the village person, neighbors, could have taken the dead body, lordship, the injured person to the hospital. Nothing has been done. But the postmortem report doesn't say so. The time says the column. I've checked the original also. It is not there. And your lordship, although she has taken a plea, she was not there, my lord. Lordship is aware of, and the plea of alibi has to be brought in by way of positive evidence. Nothing is there, your lordship. There are judgments, my lord. If someone takes a plea of alibi, it has to be by way of positive evidence.
So where are those judgments?
There are. This one. Diary.
If we steal Miss Buyan's diary, then she's finished.
It's there, my lord. It has to be brought by positive evidence. This one. 2000, Papa, not about 2010 SCC 430. 430. Sheikh Sattar versus State of Maharashtra. Para 30 to 30. No, 2010. Sheikh Sattar. 8 SCC 430. Naula?
But plea of alibi I have not taken. I have only said that I have informed the Gaon Buddha. Plea of
Oh,
alibi
no,
I have
you
not
were
taken.
somewhere
I've
else.
said that at 5 I reached and I saw. And even prosecution case in the FIR in the column of the incident, my lord, they say 7 p.m. yesterday night. It is.
And you said that you were at work
Yes.
Yes. Till 5 p.m.
by.
No, my lord, that part I have not.
And she could not discharge his burden under 106. This is an inmate of the house. It has been taken place and it has come up on evidence by both of them, nobody else were there. So she could have discharged the burden under 106. And she has shown the weapon of offense to the IO, my lord, which is lying there. Although it has not, no, that's it, man.
There. We'll do it. See, that's not a C1.
My lord, the 313 in fact says that I am a garden laborer also. The format of the deposition, my lord, speaks about I am a laborer. I reside in the Bamunjuli tea estate. And my lord, our shift is, my lord, till 5 in the evening. That is there. Either in the morning and in the evening.
Oh, so you saw your husband dead on which date?
On 21st.
And you saw him dead on 21st.
20.
And
My lord,
you
this,
informed them when?
I did not, my lord, I said I informed the Gaon Buddha, but
When? When did
On-
you, according to you, when did you inform the Congress?
on 21 itself, my lord.
21.
21 itself.
Within
Yes, my lord, they work. No, my lord, they work.
not
No,
always,
my lord.
not all the
No, my lord. It is not that on Sunday they don't work, my lord. It is not the case that they don't work.
No,
They work in
generally-
shifts, my lord. They work in shifts, my lord.
They don't have any rest day.
Some of my clients are having, my lord. On Sunday they are working, my
They're
lord.
not, they're not
Sunday হেলি বন্ধ থাকে।
supposed to have one.
They are.
They go for shopping and some people to charge.
Oh, market.
Market time.
The hearts are there, man. Heart bazaars are there on Sundays, my lord.
So the police came to the place of occurrence when?
On the next day, Monday, my lord.
Monday. And this PW1 came to the Monday morning.
Monday.
So the whole night,
This is what, my lord. This is not there. This explanation had that cut, my lord. I had a very good.
completely. And then 106. Yeah. Heard Mr.
A. Tiwari, my lord.
A. Tiwari, learned amicus curiae for the appellant, and Ms. B. Guya, and senior counsel and additional PP for the citizens. Hearing concluded, judgment to them.
Oh.
Yes, madam.
If your last date can be given on February first week,
Huh?
for, another
Why?
chance may be given for February first.
Why? Why? For what? For asking for another date?
No, Lord. No further dates.
Hmm?
The last date is.
Then what about
Last
your TCR for the cross case?
If you get, if your
Last
lordship,
second meeting.
Huh?
your lordship can direct to provide us
Where is your application, madam?
that I don't have.
Ah,
I will apply.
no, you have not applied. You have not, there's no statement made by you that you have applied.
In the
You
meanwhile,
have only said that you have inquired. It is, you see, basically you all are just adjourning the matter for adjournment sake. For whatever reasons you all are doing it, you all know better. It's basically 106 between you and the client. But for us, we have got to read a little bit before coming to court. You see, and we have accommodated you all enough time. Adjourn the matter enough time. No more adjournment next day. I think in your case there are witnesses also.
Yes, eyewitnesses.
Eyewitnesses galore.
Yes.
That is why you're not doing. So even if I do not know how the cross case evidence is going to help you. See, you have got to look after your own case. The evidence in a cross case is meant only for the facts of that case. Evidence of a cross case cannot be used here in this case. Unless you give the same type of evidence in this. Then how does it help? It's just a delaying tactic. Right. No more adjournments on the next. If you do not come, we are going to change we are going to appoint a amicus or a legal aid counsel and we're going to dispose it. Right. Third, Miss
B. Soren.
B. Soren appearing on behalf of Mr. B.D. Kaur. B. Kaur. B.D. Kaur. Learned senior counsel for the appeal. He submits that he has not applied for the records of the prosecutor. Correct. I have applied for the what? Applied for what?
The TCR copies of the cross
The
case.
TCR copies of the cross case. Till date and needs the same. We have noticed that the matter has been adjourned time and again on behalf of the counsel for the appellant without there being any actual application for being given copies of the TCR copies of the TCR of the cross. In any event, when there is a paper book already made in respect of the present case, we are unable to understand how the evidence in the cross case could be applied to the facts of this case. Last chance is provided. The last chance is given for adjournment. No, last adjournment is given to enable the appearance to apply for TCR copies of the process. The matter will be listed on 27th. No further adjournment will be provided.
February,
Huh?
February 1st week, any day.
Give February 1st. No further adjournment will be given on any ground. In the absence of, in the event of any adjournment being asked for, this court may appoint a legal aid / amicus curiae for disposal of the case on the basis of the paper book already.